the chairperson of the ELS In-House Counsel Committee, our moderator for the day, our presenters for the day, colleague advocates on this call. Good afternoon. I take this opportunity on behalf of the Governing Council of the East Africa Law Society to welcome you to this very important webinar on contracts management. This is an area that the Society places a lot of importance because a majority of our members are involved in a big way in how contracts are drafted, in how they are managed, and the success of those contracts, especially for our region, the East African region. We've in the past been involved in trying to rectify some of the skewed contracts signed between our partner states and multinationals that in most instances used our low negotiating capacity to sort of get their way. So this is a really important webinar for us, and especially for in-house counsel that are directly involved in managing contracts. I'm not the main speaker for the day. I'm going to take this back to the chairperson of the committee, Ms. Gloria Tengera, who will introduce the moderator and probably make a few remarks, and then the moderator will take it on and introduce our speakers for the day. Thank you and welcome.
Thank you, David. A very good afternoon to all of you and welcome to this webinar, which has always been created with the in-house lawyer in mind. My name is Gloria and I'm glad to be sharing this knowledge filled space with all of you. So from our first topic on creating visibility and influence for effectiveness to emerging trends in corporate governance and the impact on the role of the company secretary, today we get to talk about Contract Management 101. We're going to explore the theme, the topic surrounding what is contract management, why is it important, what are the challenges faced, and how can we address them? Before we delve into these matters, I would like to recognize the presence of our main speakers today, who will be introduced by the moderator, and thank them sincerely for taking the time to share their knowledge and expertise. As always, a vote of thanks to ELS Secretariat that always makes these webinars happen. I also would like to recognize the presence of the moderator, Amina Okwaju. Thank you so much for leading us today. As usual, this will be a very interactive session, so please make use of the chat lines and the Q&A channel to send in your questions. So without further ado, I now hand over to Amina to take over the session. Thank you.
Thank you very much, Gloria. Good afternoon, everybody. My name is Amina Okwaju. I'll be your moderator for today. We are in this webinar discussing the Contracts Management 101 for in-house counsel. And our first speaker today will be Soila Kigera. Now, a short introduction about Soila. Soila Kigera is an advocate of the High Court of Kenya with 10 years standing and is currently legal counsel of Total Energies Marketing Kenya PLC. Total Energies is a big player, as we all know, in the energy sector with an international presence. Before joining Total Energies, Soila was a commercial and civil litigator at the firm in Sagana, Birik, and co-advocates. She possesses an LLM on sexual and reproductive health rights from the University of Pretoria and is a qualified company secretary. Soila is currently the in-house counsel representative of the Law Society of Kenya Nairobi branch and heads in the in-house counsel committee that deals in creating, enabling, and responsive practice environment to further the professional success of the in-house lawyers. That is quite a CV, everyone. Welcome very much, Soila.
Thank you, Amina, for that introduction.
Yes. So today, we're going to discuss the Contracts Management 101 for in-house counsel. As we both know, this is quite, this has been quite a topic, And we have a question, Soila. As an expert and as a person of your experience and caliber, what do you say, what is contract management? How should we define it in our organization? And why is it important in every organization, for every in-house counsel to know and understand this, for those who are in-house and maybe those who are not in-house lawyers? Welcome very much, please proceed.
Thank you, Amina, for that welcome. I will start, I will immediately start on what is contract management. Contract management is managing the entire life cycle of a contract, from its inception to all the way to its closure, and using the resources that a company has to control the legal or financial risk. So the contract management process does not come to an end once you sign off your contract. That process still continues. And we will look at the different stages of contract management within an organization. Like a butterfly, the contract management has its own life cycle. And this is not a stagnant life cycle. It changes according to every organization, and you are supposed to amend it to suit your organization, to suit your needs, to suit your resources. So in this presentation, I will look at this life cycle starting from the preparation to its generation, to the negotiation stage, execution, and finally the tracking stage. In the first stage, the preparation, the first stage is where we have not gone into the drafting of the contract. We are still collating information that we need to draft this contract. The first step I would advise is to know the contracting party. Who are you contracting with? Is this party a limited liability company? Is it a sole proprietorship? Is it a startup, a company, or is it a company that is known in the market? It is important as an in-house lawyer for you to conduct your due diligence. That means finding out, is this company sanctioned? In the light of the Ukraine war we are seeing between Russia and Ukraine, we are seeing sanctions coming up to companies. And it is important as an in-house lawyer to carry out your due diligence to find out, is this company sanctioned? Is it a company that has been sanctioned by international bodies to ensure that they will protect your organization? It is also important to know where they're based, where they're located, before you start entering into a contract with a party. It is also important to understand the scope of the proposed business relationship. In this case, are you a supplier? Are you a customer? Is it a one-time contract, or is it a contract that will go on for years? Is it an evergreen contract? Is it binding, or is it a contract in where you're just exchanging information? Now, this information helps you to understand how to draft your contract, whether you will do a non-disclosure, whether you will do a memorandum of understanding, whether you will draft a lease. It is important to understand the scope of the business relationship. Many times as in-house, we are not part of the, we're not sitting at the table when they're negotiating on the business aspects of the contract. So it is important to sit down with the business teams and understand what, in essence, are we entering into, what contract are we entering into, and understand what the business is about before you go into the drafting process. It is also, as an in-house, is also important to understand the intricacies of the business. Just because you're an in-house lawyer does not mean that you put yourself aside. We call them the business team, and we are the supporting team. A good in-house lawyer knows their business, knows how their business is conducted, from the manufacturing to the supply to the delivery, because this enables you to create an image in your mind to be able to draft the contract. Because if you do not understand the business, you will not be able to protect the business. You will not be able to foresee any legal risk and how to mitigate it within the contract. You will not be able to avoid loopholes or as you are drafting the contract. So it is important for you as an in-house lawyer to understand how your business is run. It is also important to understand what are the business needs. What are we, what as a business, what is their need in this contract? Do we need some money? And so therefore we look at our, at the interest rate. Are we supplying products? Are we trying to push product out there? So as a person who is drafting, we need to be more lenient to a customer. So we look at the needs of the business, and this entitles us, it now enables us on how we will set the contract. When a person is supplying us a product, we might be a bit more tighten the reins on the contract to ensure that we are protected. So identify what is the need of the business in this contract. It is also very important in setting, in foreseeing risk, because once we understand what the company needs, if we are being supplied for a product, we are able to foresee that there may be a force majeure, that they may delay and put in delay penalties. We are able to look at the payment time. Do we want to pay within 30 days? Do we need more time, like 60 days to pay for our products? How long will it take for our products to get to us? Certain key performance indicators that we put within our contracts to ensure that we are protected and the company is protected. And this contract, what impact could it have to our existing obligations? For example, if you're entering into a contract with your competitor, what does the law say about entering into the contract with your competitor? You must ensure that you do not cross competition laws. So as you're drafting, what information are we exchanging? Are we crossing over to a very dangerous line where we are exchanging information that could have sanctions or bring us sanctions, or a breach or certain punitive measures brought against us? So have we entered into an exclusive contract before with another parties, which says we cannot enter into other contracts with other parties on the same product that we want supplied or a service that we are giving? So it is important that we know what are our existing obligations before we enter into another contract with a party. And before we start out this the drafting process, it is important that we collate all the information, identify the contracts that we may need, identify the related documents that we may need. We may need to look at the laws, read through the laws to see what laws are speaking about supply, what laws are speaking about, what are the new laws, the business laws on e-signatures, what are the business laws on supply, on data protection. We need to look at that. We also need to identify contracts. Is this a new contract, or we are amending a contract that is already existing? What other related documents? Look at the policy documents of your company. What does your company say about this contract? What are the policies surrounding this? What are your policies on safety? What are your policies on entering with a supplier, maybe from a different jurisdiction? Are there certain policies? So you review all these documents before now you go into the next step of now drafting the contract. It would be advisable to come up with a letter, a term sheet, just stating out what, as the two parties, what have we agreed on? What is our duration? What is our term? Certain core essential terms within the contract. Now, once you have agreed on these core terms within the term sheet, it now becomes very easy for you to go into the drafting stage, which are now called the generation stage. In this part, we are either generating a new contract from scratch, and which can be very time consuming, especially as an in-house lawyer, and especially in a multinational company, or you're serving very many departments. You cannot keep on recreating contracts every day. It is advisable that you create templates, a template for when you're a customer, a template for when you're supplying a good or service, a template for banking, a template for procurement. In that way, when you're called upon to do certain contract, you just go to your repository and take up the needed template. But even as you need to be very cautious, even up with existing templates, that they are up to date with the laws. You do not take a template which is referring to a law that has been repealed, or there's a newer law that you need to know of. So you need to ensure that you keep on updating your templates, and that you just don't copy and paste into your template and you forget to look at what the circumstance is here. Sometimes we need to beef up our templates to ensure that we protect our company, because maybe there's a new scenario that has not been covered within your template. And what templates help you to avoid is to help you avoid losing out on significant clauses, because they are automatically included. Losing out on certain key policies that have to be within all your contracts, losing out on information that you do not allow. Maybe your company does not allow credit. So within credit terms or advance payment. So the goodness of templates is that it captures all this and it reduces the risk that you may have from starting with a fresh contract each and every time. We, however, have to ensure, even though we are using templates, that we are not ambiguous. We do not leave vague clauses. We do not have vague clauses. We need to be very clear. We need to be very concise so that we do not leave room for interpretation, which can bring up issues later on when conflicts arise. And in every contract, there are certain crucial, essential clauses that have to be met. Some of these essential clauses are termination. When can we terminate as an organization? What is our duration of termination? What is our notice period? What are the non-negotiables like for a company? If they do this, we are going to terminate even without giving notice. For example, I'm in the oil industry, I'm in the energy industry, and for us as an industry, safety is key. So for us in our contracts, when a person breaches safety, which can have repercussions not only for the company, but also for the environment and the people, we put very stringent termination clauses when it comes to safety. So for your organization, it may be banking or a different sector. So you look at what is essential in your organization and put in certain stringent issues on termination. But also we must, even on the other hand, as an organization, you protect your organization that may have a way of escape, that you are not forced to be in a contract longer than you want to. So always prepare a way of escape clauses for your company in form of termination. Termination on convenience. When this business no longer suits you, you must put in that to be able to terminate on convenience. These are very important for your company. We also have certain corporate policies that must be in our contracts. For example, anti-bribery. We are living where internationally we are, as communities, as nations, we have become an international community. And there are certain things that are frowned upon internationally, globally. For example, corruption, certain key, you cannot miss out on putting anti-corruption clauses to protect your company. We also sanction clauses that enables your company to come out of a situation where you're doing business with a company and you find that this company has been sanctioned. It enables you as a company to be able to come out of certain relationships with a contracting party. We're also looking at human rights. Human rights is very important in this day and age. We are talking about child labor. When a party is providing for you services, you ensure that this party is not using children as part of their labor force. So certain key clauses have to be there to protect you as a company. We are also looking at inclusivity, even in human rights, and non-discrimination. We are also looking at an anti-bribery and corruption, which is a very big thing right now. And we know the hand of the laws nowadays past the borders. We look at American laws, which go past their borders, even into the African countries. So it is important, even as you're entering into these contracts, that you know the anti-corruption laws that nowadays surpass our borders. And as you're drafting that into the contract, to be able to protect you, because not all the times that our contracts will be between people from the same jurisdiction. It is also important to set out the laws that will govern your contract. Is it the laws of Kenya, the laws of Uganda? It is important that is set out. And when we do not agree that it is the law of Kenya or the law of France, we could agree on a law of a different jurisdiction. The English laws are what will govern this contract. Okay, when we have a conflict, are we going to arbitration or are we taking this matter to the courts? It is important that is clearly set out. And what laws will govern the arbitration process or the mediation process, that needs to be clearly set out. The duration of the contract. It is important that you ensure that it is not an evergreen contract. Evergreen contracts can bring financial issues for your company, because we have not set a date. So even when you want to come out, it is not clear that this contract was just for 1 year or for 3 months or it was a one-time contract. The duration of a contract is very important. Payment terms. Payment terms, we look at how long are you allowing a party to pay you? Is it 30 days in which they need to pay you? Are there credit terms? What are your credit terms? And as an organization, do they need security before you can give them credit terms? And are they supposed to pay in dollars? Do they pay in checks? Do they pay through EFT? All these have to be clearly stated within your contract to avoid issues. And we know payment is one of the very major issues that brings issues to, brings conflicts, especially between contracting parties. Force majeure has really come alive during this time of COVID. We have seen this clause come alive so many times during this COVID pandemic, and it is important that the force majeure is very clear for you as a party. When can we terminate a contract when a force majeure arises? What constitutes force majeure for you? For some people, even during the pandemic, force majeure did not come into play because they said there are ways that the company could mitigate it, or there are ways they could go around it. So what constitutes force majeure needs to be very clearly set out in your contract. And when you can terminate. Are we choosing to terminate, or are we choosing to see how we can negotiate as a contracting parties and find a way of holding this contract even in the midst of a force majeure event? So it is also important for force majeure to understand, how does this force majeure impact my company? Are you the supplier? Are you the customer? Because it does not impact you the same way. If you're a supplier, you might want the force majeure period to be extended. If you're the customer, you might want the force majeure period to be shorter, in which the time in which you can terminate a contract so that you can seek the services from another supplier. So it is important to look at that. It is also important to set out clearly the obligations of either party. So clearly, what is Total doing in this contract? What is the other party doing in this contract? Set it out very clear. It should not be ambiguous. It should be very clear what each party is doing in the contract. After you have generated this draft and you've put in the essential clauses, we also need to ensure, even as you're generating, that you have put in timelines for yourself. Sometimes we take too long to draft a contract. We take too long in the review process, in the back and forth as lawyers. We go in our nitty-gritties, and we might be caught up in the review process, and we want to be right. And we forget that this is a business, and in a business, there are certain timelines that have to be met, that we lose on certain core business because of our nitty-gritty going back and forth. So even as you're generating contracts and you're reviewing them, it is important that you put certain timelines to ensure that the organization will not lose business in the review process. And this is where we come into the negotiation. We have drafted the contract. We are now going back and forth with the contracting party. in this part, you need to have certain non-negotiables for you. As an organization, we say one of our non-negotiables is that we do not give advance payment. One of our non-negotiables is that we do not allow whatever your non-negotiables may be. You need to have certain non-negotiables. For example, the laws of Kenya have to apply in all our contracts. So as you're sitting there with the contracting party, you know these are your non-negotiables. You may bend on this clause, you may bend on another clause, you may find a halfway on other clauses, but there are certain non-negotiables. You're saying for this, we may not enter into a contract because of these certain non-negotiables. But this changes from organization to organization, sector to sector. If you're the supplier or if you're the customer, this will change into that. So do not be very stringent. You need to look at the situation and decide these are our non-negotiables. And even as we are reviewing and we are going back and forth with the contracting party and we have tracked our changes, it is important that you evaluate every change that has been made by the contracting party. Go through the document, be very keen to evaluate every track change, because it is very dangerous that they have put in a clause, you have gone and the organization has signed the contract. And once you have signed the contract, you find that you are now forced to meet a certain obligation, which has has financial impact for the company, or you're going on losses, but it is already too late. You have signed the contract and the clause is there. So you need to be very keen in this negotiation process that you track every change, and every change that has been tracked, that you read it through. And even after the track changes are done and you have gotten all our approvals and you have the hard copy or the soft copy as it may be for signing, before it goes for the execution by the signatories, ensure that you read through the contract again to see something that may have been added in the back and forth during the negotiations, to ensure that you are not locked into an obligation that will have a financial or legal impact on you. The next thing is also to work together with the business teams. As you are a legal expert, it is important that you know the business, but sometimes the business teams, most times the business teams are more familiar with the limbo or of the sector or more than you are. So it is important that you work together with them during the negotiation process. They be more equipped on the business terms within the contract than you are. So it is important that when you're negotiating, that you work together with the business team to ensure that you have a well all-rounded contract that protects your organization. For example, we may look at the interest. You may look at the delivery. As an organization, you might not know as a lawyer that it will only take 3 days is too short for delivery of a service or delivery of certain goods. But the business teams may know 3 days is too short. So, and they may trade certain red flags that need to be amended within the contract. And therefore it is important that you work as a team. Once you have done all that, you have drafted, you have gone to the back and forth, and you have captured all the changes, and now you're ready to have the contract executed. Before execution, you need to have certain things approved. This may change from organization to organization, but there are certain approvals. You need to identify what approvals do I need to get? Who needs to approve this contract before this contract is signed? Is the money that is being spent within this contract, is it within the ambit of my head of department? Is it within the ambit of my managing director? Is it within the ambit of the regional director? You need to find out that and ensure that the approvals are signed, all the requisite approvals. Sometimes we may not be able to avoid risk within a contract, but once you have set out this risk to the business, you have told them, this is the risk that you will face if we go on with this contract. And you have shown them that you have mitigated as possible as you can. The company may still say, we will go ahead with this risk. It is now important that this is noted down and you get approvals on the risk that is acceptable to the company. Because later on, some of these things may have an impact on you as an in-house lawyer. We have seen that where things turn around and everybody is pointing at legal. So it is important to ensure that you have gotten written approvals on what risk is acceptable to the company. In certain scenarios, we may need to waive a company rule or a company procedure, and you need written approvals from the departments or from the heads of departments or from the directors that yes, we have agreed to waiver this procedure or this policy for this contract. So that you need to get those approvals need to be in writing, or if they're in the system, in a system which allows these approvals, ensure that these approvals are received before you go into the next issue of execution. Certain approvals are from regulatory bodies. Have you gotten the requisite consents before you can continue with this contract? Whatever form that contract may take, it may be in the form of a lease, and you may need certain consents from regulatory bodies. So it is important that you have gotten all consents before you go to the next step, which is the signing of the contract. Once the signing of the contract is now what makes this contract valid. Once we know that now signing of contracts does not take, the signing of contracts has taken as new form. There is the in-person signing or the e-signature. And it is important as an in-house lawyer to understand, are we signing in person? Are we signing using e-signature tools or software? And if you're using e-signature tools or softwares, are they allowed by the laws of the country? Do the laws allow certain e-signature tools? Have they gotten the certain authorizations from the communication authority or of your jurisdiction to use certain tools or software? And if there are no laws that govern execution using e-signature tools in your jurisdiction, you may need to look at the contracting party and their jurisdiction, and what does their jurisdiction provide for e-signature tools. You may also need to look at your policies, the company policies, because we know sometimes company policies come ahead of our laws, because our laws submit the amendment of laws or coming up, enacting new laws. Sometimes the procedure or the process is snail-paced as compared to our policies or procedure. So before you sign that document, you maybe either e-signature or in person, ensure that the policies, the procedures, and the laws allow the signing through e-signature tools. Also, you may also need to look at your organization. What does it provide and how proper execution of documents is done? What are the articles of association of your organization talk about proper execution? Do they provide for 2 directors? Do they provide for a director and a company secretary? Do they provide for a seal? Do they provide for a witness? Once you have known all this information, ensure that your document is properly executed. We have now executed our documents. We have witnessed them as the lawyers, and now, and according to your procedure of your organization, and now we think that the contract management process is done. But the contract management process does not come to an end once we have executed a document. We need to follow up with what I call tracking the what we have agreed on within the contract. We may need to do an audit of the contract to see whether parties are complying with their obligations within the contract. You may need to put in certain key performance indicators to see how your supplier is meeting his obligations within the contract. Are they honoring timelines? Are they honoring quality? Are they honoring the services? Are they meeting the timelines that they told us within the contract? These key performance indicators are also very important when the contract has come to an end. Maybe the contract was for 1 year and you're deciding as a business or the business is deciding, are we going to renew this contract or are we going to get another supplier? Key performance indicators help us to look at that. Have they met the obligations in the standard to which that are set out in the contract, so that we can renew for a second term, or we can say, no, they did not meet, they did a very shoddy job as per the indicators within the contract, and we will not be renewing this contract. We also need notice periods. Some contracts say that this contract will be, you must give us a 3 months notice if you want to renew this contract. If you are not tracking your contracts, the 3 months will come, you will notice it is 1 week before the contract is going to terminate, and you have not started you did not give notice into your renewal. And this can have consequences for your organization, financial consequences, or even legal consequences. You may even lose on good business because you did not take you are not tracking the notice periods. You may also need to amend contracts. You have gone through the contract and you notice that there are certain things, or you might want to extend the term of the contract. You might want to expand the scope of the business or the contract. This is where contract amendments come in. You need to keep track of all the amendments of the contract. Some contracts have amendments up to 7 amendments, depending on the nature of the contract. We may be changing the price, but we are not changing the goods or the services that are being provided. So it is important to ensure that you're keeping track of all the amendments. You must, especially in this digital era, it is important to have a software tool that is keeping track of all this, information, because it is not possible for you to keep track of all on this information together with all the other work you do apart from contract management. So it is advisable as an organization that you have a software tool that keeps track of the key performance indicators, of the deliverables, of the notice periods, of when a contract will be terminated, of when we need to start renewing, of when we need to start negotiating. This is important. It is also important to avoid auto renewals because it gives you a chance to renegotiate. And when you do not keep track of your contracts, you will see auto renewals. And it can have devastating consequences to your organization. And it also gives you an opportunity as a company to renegotiate on the pricing. Maybe this time the pricing was not very fair on you. And you might want to decide we will go with another supplier or renegotiate with the same supplier that they provide us services or goods at a better price. Also, it is important to keep track of your contracts to summarize the achievements that you've made within this contract, even as the legal department and as you're making a presentation to the business, you say, because of this contract, these are the achievements we made from this contract. We were able to reduce the defaults or breaches. Because of this, we were able to save this amount of money because of the clauses that were inputted within the contract. These are the return on experience from what we saw from this contract, and we would advise the next time that we're entering into a contract, we use a different supplier, or we use different clauses, or we use better payment terms or better credit terms. So this enables you to keep a track and enables you to give good feedback, not only to the management, but also to the business teams, but also to you as legal to keep track of your risk to mitigate financial or legal risks. Tracking also involves document retention. How do we retain once we have signed our documents? Are we retaining our documents and in an online or online portal, or are we putting them in files? How have we numbered them? Do we have a central repository for all our contracts? Do we have easy access to all our contracts? Who is able to access this contract? It is important to be able to put safety measures on who is able to access these contracts, because of the very private information that is in in this context that may need to be protected, it is also important to have a retention policy. When can we keep documents and when can we destroy documents? Because we cannot keep there's some documents we can keep for 1 year, 3 years, 7 years, 10 years, depending on the laws. As you're creating this retention policy, you need to look at the different laws and how long do they
Recording in progress.
Pardon? Is anyone saying something?
Please proceed.
Okay.
Please proceed.
Okay, the retention policy, it looks at the laws. What are the tax laws talk about how long you should keep the documents, and other laws to ensure that you retain your documents for the required time under the law. And this also helps you to know when to destroy documents, because we know we are still not paperless. We still keep some of our contracts in the paper form, and we need to store them. And sometimes we even have to pay for this storage space. So as legal, we need to have a retention policy to decide how long will we keep documents before we can destroy them, because to mitigate or to reduce our storage costs. Even our retention policies also help us to know how long we'll keep a document, because we know a conflict may arise and we need certain evidentiary documents to provide in court. And if we have not retained our documents, then we will have a problem when we are trying to prove our case in court. So it is important that our documents are stored well. They are accessible, they are organized, they are in one secure location. May it be online or is it in a paper form? And we must ensure that we limit access. Is it in our laptops with passwords, encryption? We might also locking or who has access to a repository of our contracts. So that is important. And finally, we see the importance of a good management system. Why do we have contract management system? Why is it important? One of the reasons why it is important is it makes this process faster and less risk. If you have a template, if you have a checklist of what essential processes have to be in your contracts, if you've gone through the approval process, it reduces the risk. It makes the negotiating, execution, and the renewal process faster and seamless. And it saves us on time. Once we have a certain process, it saves us on time. We do not take 3 hours looking for where did we keep our last contract, where is the we want to do an amendment and we cannot find our contract so that we can look through it. It is important when we have a good management system, we save time. Corporate memory. What I'm talking about corporate memory, you might not be in that organization, but once you leave that organization, because of a good management system, contract management system, even the people who come after you are able to access information, able to access documents, and continue and these seamless handover. A good management system also helps you to avoid legal and financial risks, because when you miss crucial milestones in a contract, there are certain financial risks that you may face, where there are auto renewals, as I've talked about. You may be forced to stay in a contract longer than you need to. If you do not, a failure to keep track of your contracts may cause non-compliance. Non-compliance has punitive consequences. So it avoids legal or financial risk. It also helps in cost management. According to the World Commerce and Contracting, it talked about contract management helps to reduce costs of an organization 9% of their bottom line, meaning that it affects 9% of the bottom line of an organization because of the failure to put in good contract management system, it can have an effect on the bottom line of a company, because we have failed to mitigate risks, we have missed crucial timelines, we have gotten punitive measures, regulatory bodies have meted out sanctions against us because of our failure to meet certain crucial obligations within the contract. Litigation costs have come up because of breach of contract. So it is important to have a very seamless contract management system. It also helps in regulatory compliance, because if KRA, for example, or the revenue authority in your jurisdiction requires you that you keep a certain document for 7 years, if you have not kept that document, when the revenue authority comes knocking at your door and they expect you to prove, okay, let us see the contract, let us see your obligations, let us see that you actually paid, that you met certain obligations under your contract, that these are the payment terms, that VAT was actually in the contract, or this party was exempt from VAT. Certain contracts, these contracts will be used to help us with regulatory compliance. And it is essential that we have this system put in place. This system, and as we're moving into the tech era, it is important as an in-house lawyer to even talk to your organization about putting in an online management system, or a tech management system, that we are just not using paper, that we can have a system that enables us to draft, to review, to negotiate, to track. And this system is comprehensive, and it can incorporate even the business teams. And it is something as in-house lawyers that we should speak to the management or speak to the business about coming up with a technology that helps proper contract management. And thank you for this, for listening to me. And I am open for any questions that you may have with the presentation, and any comments that you may have. Thank you.
Thank you very much, Soila. We can see you have a lot of questions, a lot of hands have been raised. But for the purposes of saving time, I think we should first let Caroline cover her part, and then we'll get back to you as you try to answer them one by one on the side. I think we should do it that way. So Miss Caroline Simba, where are you? Are you here? Hello, Caroline. Good afternoon.
I'm here, Amina.
How are you?
I'm very well, thank you. How are you?
I'm fine. So, dear audience, Caroline is our next speaker, and I would like to introduce her briefly. So Caroline Simba is a seasoned governance expert, lawyer, and a corporate business professional with over 20 years of experience. She's currently the Chief Legal and Regulatory Affairs Officer at Jamii Telecommunications Limited. Previously, Caroline worked at the reputable and well-known firm of Kaplan and Stratton. And she's a natural leader and voted top 40 under 40 by the Nation Media Group in 2010. She has sat in various task forces nominated by the government to keep national ICT policies, including chairing in technical committee under the Ministry of ICT, whose work led to criminalization of vandalism in the country. She has also heavily participated in development of Data Protection Act in 2019, as well as the National Frequency Spectrum Management Policy of 2020. She's a qualified UK trained lawyer, human resource practitioner, a certified public secretary, and an expert practitioner in corporate governance units, and compliance. She has a corporate secretarial practice. She understands corporate law, consultation, and business management and administration. She holds 2 master's degrees in human resource management and another in law and a bachelor degree in law. Caroline is also a member of Law Society of Kenya, LSK, the Institute of Certified Secretaries, ICS, and Institute of Human Resource Management, IHRM. Caroline also serves on the board of Ulu Conservancy Limited, KEPSA ICT sector, Mhasibu Runda Welfare Association, where she's the chairperson. And in addition, she's a mentor at the M-Pesa Foundation Academy and UK-based Beacon Scholarship. Wow. Now this is quite a CV. Don't we all agree? So Ms. Caroline, today we are discussing Contract Management 101 for in-house counsel. And we have a question for you. So we have heard Soila. Soila told us the definition, its importance, and why we need it. She spoke about preparation, knowing the contracting party, knowing the type of contracts, knowing your company. She spoke about generation, negotiations, execution, and tracking. She said it's important because contract management helps in saving costs, avoiding legal and financial risks. It saves time, it's good for corporate memory and regulatory compliance. Now for you, we want to ask, what are the challenges faced or are likely to be faced in uploading contracts management, like in maintaining contracts management in an organization? And how can we tackle the said challenges? Like how can we avoid them? Or how can we cure those challenges? Please welcome very much, Caroline.
Thank you so much, Amina. I'm really excited to be here. And I would like to say I'm currently at a working retreat outside Nairobi. And I really hope that my internet behaves, that we'll be able to finish this presentation. You know, when I was approached to give this talk, I spent quite a bit of time just trying to think, what message would I want to pass across? And I say that because as lawyers, we have a tendency to have a very closed mindset. You know, we are trained as lawyers, we see things in black and white, but businesses don't operate in that manner. Businesses are about numbers. Is this enterprise making money for its shareholders? And it's very important for us lawyers who work in-house to go into our professions and our careers with that mindset. And I like that Soila laid the foundation for us in as much as what we need to look out for before entering into the contract and during the contract phase and post-contract. But I am going to approach this conversation really from a strategic perspective. And one of the reasons for that is because if you look at the statistics globally of professionals who take over CEOs, the statistics show us they are either general counsel or CFOs. And that means that then as lawyers and general counsels or whatever level of leadership or management we are in, we must be able to understand our businesses through and through. Actually, I like a statement that's always made that lawyers are the co-pilots to the CEO. And so Soila has taken us through what the contract management process is. I'm not going to repeat that and why we do it. But with my strategic mindset, I just want to highlight 2 items that are here in my presentation. And one, as you can see, I hope you can see the image to your left. I think it's to your left or to my right, which is that of a hat. And a lot of times we forget that contracts are living documents. you don't prepare the contract and then you pack it aside and you forget about it. And typically, I think many of us are guilty of doing that. We only remember the contract when somebody asks for it or there's a conflict, and all of a sudden we are scrambling to look for the document. But if we remember that it's a living document, it's like your heart, it's the heart of the organization or the legal department. And as with your heart, you nurture it, you take care of it. And so the same thing goes to contracts. And the reason we do that is because what the business expects of us is that we must be able to reduce financial risk and, most importantly, maximize the operational performance of your company. So you must remember that constantly, that when you're entering into a contract, you must be able to ask yourself, what is the value that the company is getting out of that contract? Again, Soila has taken us through the planning phase, the negotiation and execution, and then the management and the closure. So I will not repeat that, but there's something that I also want to highlight from this presentation, which is the health and condition of your heart. Remember, we said that the contract is like our heart, it's a living document. And so the health and condition of that heart is heavily dependent upon deliberate actions that are taken to improve and maintain its health. And so with the contract, what are those deliberate actions that you're taking as legal counsel to make sure that you're improving the process and you're also maintaining it in a certain standard that then has been set by the organization or by the department? And I always approach my contracts from a strategic perspective, because again, as I said, having worked at management level, I look at contracts from a financial perspective. And I really want us to take away two things, which is the strategy in the upstream activity. The upstream activity is the onboarding exercise, what you do prior to getting into the contract. The strategy is, one, you want to have a good procurement plan, okay? And so it's very important that you work with the procurement department to understand what exactly do they want out of the contracting process. In most organizations and definitely the large organizations, what they do is that the procurement will evaluate the vendor and they will create a matrix on their expectations, the deliverables that the vendor must be able to deliver on. And so as the legal, you come in to support that process. And so you have to look at that planning. Is it in place? If it's not in place, there is no problem with you discussing with the procurement department to initiate it. And the reason for that is that when you're carrying out the due diligence on who you're going to contract with, it's important that procurement is in that process. The second strategy in the upstream activity is having a comprehensive specification, and Soila took us through this, is that you must have a good understanding of the needs of the business so that you're able to accurately describe them and capture them in the contracting exercise. And that is why I always say, lawyers, please do not work in an island. Do not isolate yourself from the business. You must be a partner, a business partner to every department to be able to understand what their needs, what their concerns are. And then the other strategy alongside the upstream activity is the right contract selection. One time you can be asked, we want to onboard a new vendor. And the reason for that is we are acquiring new equipment. Now, the question is then, what is the contract type that you would prepare? Okay, is it a consultancy agreement? Is it an equipment purchase agreement? What exactly is it? And you must be able to understand, because then that determines the deliverables and how you capture and scope the obligations of the vendor. And then the careful now supplier selection is the final strategy alongside that. Do they have the capacity? Do they have the capability to be able to deliver? A lot of times you might find that once you've done that due diligence exercise within the upstream activity, that that actually is probably not the best supplier. Maybe they don't have capacity from a financial perspective to be able to deliver to your expectation. And so that exercise is very important, because once you're able to put that in place, it makes the rest of the process very easy. And that's the downstream activity. Again, I'm just going to highlight the strategy because Soila has taken us through what that entails. The strategy is to have a sound contract management plan, a practical, thorough plan. And I want to highlight here, practical. Do not copy and paste. Make sure that you customize the plan to your unique organizational structure. And the purpose of that is to be able to it must be proportional to the size, the value, the scope, and the complexity of the contract. And so what you will find in most instances is that the contract management plan will not be just one. You have high value contracts which demand a different management plan. And then you have the low value contracts that would then also have a different management plan. But at the end of it is to be able to then capture exactly what that exercise of onboarding and then the downstream activities would entail. And then in addition to that, the other strategy is to have a proactive delivery management, okay? Managing the contract implementation systematically with sufficient flexibility where required. And this is very important because a lot of times as legal department, and I found this very much early on in my career, is that every department is throwing contracts at you. We want this, we want that. And everybody has a very tight timeline. Everything is urgent all of a sudden. And so as lawyer, you're left scrambling to complete all this work. And what happens is that the quality of your work starts to suffer. You start churning out documents that you have not given proper attention to, which could definitely expose the business. And so when you have a good contract management plan, you're able to scope and you're able to create flexibilities within that system where you know this activity, I don't have to engage so much. Yes, it's important, but I don't have to engage so much because either it's not a high value contract that then does not demand so much of your time. The other thing is good relationship management. Again, this is very important because if you're able to understand and communicate effectively with the teams that are depending on you to deliver, is that then it means that it makes your life easy because you're able to understand their needs and you're able to implement them. And that's a strategy in itself. And I say this because one of the things that I realized, again, as I continued growing up in management, is that lawyers, we operate in a cocoon. And so a lot of times you get instructions on email, you don't engage with your colleagues. And what that means is that the relationship suffers. So it becomes very transactional. You just act on instructions sent without really taking time to sit and understand their concerns. And what I have found is that why this is important is because once you create that good communication channel and that rapport with the various either heads of departments or team members, is that sometimes you actually realize that what they are calling a need, a contractual need, is really not a need. It can be serviced in a different way. And that's where you come in to give that support so that it's not, as I said, very transactional. Systematic administration is, Soila took us that through having a very good, solid contract depository system. And for all intents and purposes, what I recommend is always an automated system. And I'll come back to that much later. And then the ongoing monitoring and evaluation. I've really just gone through this very high level because Soila had already taken that. So Amina asked me a very straightforward question. What are the challenges faced in upholding contract management? And I want this to be as practical as possible. What I have seen in my career is that there are two items that I think bring on the challenge. One is the organizational structure. If you work in a small organization, your concern is preserving costs and resources. And because most of the time, SMEs do not have a huge workforce. They are very limited on cost. And so for them, when you start talking about a contract management system, it's not a priority. They expect you to manage that effort without having to go into the bank. The other challenge is when you have a bureaucratic system, as with most, I think, and I would say public entities and government entities, you find that the process of getting even just instructions is so lengthy. The process of delivering is again very lengthy. And the process of even requesting for an advanced system, nobody would even understand. It's not a priority. And you know, I remember very early on when I moved from working in private practice and going in-house, I struggled to show my value because the business really looked at the legal department as a support system, not a critical strategic partner to the business. And so, and that's typically what happens. And so to justify your demand for financial resources, it usually is an uphill task. The other challenge is when you have fragmented decision-making. And this usually happens, again, I think in public entities or systems that are bureaucratic in nature, where maybe you have to go through the procurement department will make one decision, the CEO of the organization has a completely different feel and need for your department. And so because of that fragmentation, the decision-making becomes so strained and so lengthy that at some point you basically just give up. Fractured transparency and accountability is another challenge. And I think in most of the times, because companies still struggle to date, most of the companies struggle to see, as I said, the legal department as a strategic partner, is that then when you request for resources, it's always looked at not as a priority item. And so it's given second priority. Leadership is another major challenge. If you don't have a leadership that understands the role of the legal department, and really that role from a strategic perspective, as a core business partner, I think it really becomes a very difficult task. And what that means is that you end up having an engaged, sort of hands-off leadership who it's all about transaction. Give us this contract by this day, and that's the end of the conversation. I think with such a setup, what happens is the contract process only becomes critical at the end. In fact, in most cases, what I have seen is that companies commit themselves to what we lawyers, yes, are calling contract, but to them, there is no engagement with the legal department. You only come to find out once discussions have been had and commitments have been made. No contract was ever even finalized. And it probably even comes to your attention when it is a crisis or there's a dispute that has arisen. And now you're asking, when did we even close this contract? And that really points to the leadership. A leadership that is uninformed. And I find this typical in cases where you have, I think, the old, very old generation that is very rigid, and rigidity is one of my other highlights, where they are so set in their way, and things probably have worked pretty well for them over the years, that really when you start telling them that we need a contract management system or we need to start tracking our contracts, nobody's listening to you. And that also means that they have an unprogressive mindset. So leadership is very important and is a major catalyst for what could be failure within an organization. Now, I want to look at these challenges from a three-pronged approach. And I'll just sort of to sum it up. One is planning, the second one is resources, and the third one is governance. when I talk about planning, is failure to plan. And I say this because in as much as we appreciate the challenges, either from an organizational structure setup or a leadership perspective, I am now talking from the point that you have been hired, you're working in the organization. Those challenges notwithstanding, you have a job that you must deliver on. There is an expectation, unfortunately, and that expectation might not be obvious, but people do have an expectation. And you come to realize that there's an expectation when things go wrong. Okay, and I want us to look at what are the consequences, because when we appreciate the consequences, it makes it easy for us to then figure out what needs to be done, because you cannot act as though nothing is going to happen. It's important for you to always make sure that you deliver. If you don't plan, the consequence is either mismatched expectations. So the business has its expectations, you have your expectations. You're probably, as lawyers, I know most of us will just default to our contract of employment and say, this is what I was hired to do. But the business has other expectations. And so if you don't plan adequately, that is what you're going to have. The other one is the consequences, complexities and dependencies are not understood. Again, mismatched expectations. So issues are not understood and nobody is coming to the table to discuss them. Inappropriate choice of contract, and that is inevitable, because if the expectations are mismatched, then you don't understand what the business wants. You go and prepare a contract based on what you were trained in law school to do. And at the end of it, you deliver something that the business does not understand, and you probably don't also understand. And again, we only come to find out when things are going wrong. Critically is vulnerability to fraud and or corruption. If you do not plan the process, what you find is then that anybody in the organization can actually close a contract. Yeah, because they can have access to the suppliers, they can go and discuss and have a contract, and then it is brought to your table and you're told this was closed a couple of weeks ago. It's already a commitment. Even if you sit there and shout to the high heavens that I was not involved, a contract has been closed. And by the way, let's remember what we learned in law school, that verbal contracts, verbal commitments can also amount to contracts. And so planning is very, very important, very, very important. And early on, you must be able to put that plan in action. And I will talk about the contract. I think I briefly mentioned the contract management plan. That's where that comes in. Resources. Now, I can tell you without fear of contradiction that many times the organizations will tell us they don't have sufficient resources. I don't know if anybody, I wish I could see all your faces, or by a show of hands, but typically most organizations will say resources are not sufficient. But at the end of the day, you're expected to deliver. But it comes a point sometimes where insufficient resources, and I'm talking about both from a capacity and capability perspective. Capability is where you have people that are not well trained, and it could happen. You have inexperienced lawyers within your team, because again, maybe the hiring process is one that is very constrained, or one where maybe you don't have much involvement, or you have inexperienced people. Anything could happen. And then capacity is what could be either financial resources or logistical resources. The consequence of that is inexperienced contract management team. And we have seen this in organization, and I am afraid to again say, especially public institutions, where you have people who are hired because they were somebody's relative, but they don't have experience. And yet you're probably having to deal with a contract that is worth such huge value to the company, that if anything goes wrong, the risk is so immense. But again, people don't pay attention to that. Slow progress, where contracts take forever to complete, and those delays could expose the company. Poor contract management, again, you have there is no way you're managing your contracts. You have no structure, you have no framework, because everybody is doing whatever it is that they're hired to do. There is no cohesion, and again, it could be because of capacity or capability. And then disputes arise. Those are the consequences, which leads to poor relationships internally and externally, and delayed mobilizations and deliveries, which we know, again, could have huge repercussions. The final one is on governance, inadequate governance. And this could be either from a leadership perspective or structural perspective, where you have a poor monitoring system. And I have seen this many times where maybe you've been in an organization for a short time or a long time, but you have no idea where the contracts are. Soila mentioned this, where you're asked to produce a contract and you don't even know where it is. How many times have some of us gone to your other contracting partner and said, kindly send me this contract, I can't seem to find mine? Yeah. Inadequate evaluation of your contracts. You complete the contract today, pack it away, and never look at it until maybe it's time for renewal or you must terminate that contract. Inefficient risk identification and mitigation, again, related to what I've talked about. There is no evaluations mechanism in place. Failure to achieve contract performance, and that's unnatural because you're not tracking your contracts. And Soila also took us through this. You have no way of tracking the performance. So whether the supplier delivers, doesn't deliver, under-delivers, nobody is tracking until there's a problem. Failure to enforce the contractual remedies, and that naturally flows from failure to have a performance monitoring process. So how do we overcome these challenges? And again, my strategic mind naturally always wants to look at things from, as they say, a smart analysis, where you're able to actually track everything that you're putting in place. Lawyers, regardless. So what is the key objective from a strategic perspective? Expected, as you can see from this circle, there is the middle that talks about what are the expected outcomes, okay? For me to be able to achieve, to overcome the challenge, what is the key objective or what is the expected outcome? The first is legal certainty, not false security. And I say this because many a times, and I think if I was to ask all you lawyers, we are about 500 of us in this room, how many contracts do you have in place? Very few of us know. Within your organizations, how many contracts are coming up for renewal within the next 3 months? Very few of us would have that answer. So what we are living in is false security that we have a solid contract management system. What we want, the key objective is to have absolute or near absolute legal certainty that our contracts are as secure as we believe they are. And security is not, I'm not talking about physical security of them being stolen or fraud happening. I'm talking about the security that we know we have contracts, we know our commitments, we know the value of those contracts, we know when they are due for renewal, we know who the suppliers are. That's your job. Having an integrated solution, not isolated solution. And the reason for that is that businesses you do not want to have a siloed organization where, again, the finance department could be having its own contracts, the procurement department has its own contracts, the technical department has, you want an integrated solution, because at the end of the day, if it is a financial, if it is a contract with either financial or any other form of commitment within the organization, it must sit with the legal department. Digitalization is key. I work for a tech company, and what we finally implemented is an automated system. And what that system does is that it tracks the contract process from inception. So anytime any department wants a contract, it goes through that system. There's a request process. There's a process of us evaluating with the procurement team. There's a process of us starting the negotiations with the vendor, the due diligence, the process of us concluding that contract, negotiating, concluding it. And then that's the system that gives us the triggers on when these contracts are due for renewal or due for expiry, or when there's a milestone within the contract that we need to inform the other departments that there's an upcoming milestone, or there's a condition that has not been met and needs to be met. So we do that within the system. Because let's be honest with ourselves. You can manage 5 contracts, but you cannot manage 1,000 contracts. You're only human. And so you, as the legal department head, must be able to show value to the company of going digital. And then internal and external compliance. Again, we are operating in a society where, you know, technology is making it, we're operating, you know, almost from a globalized level. And so you find that, and especially in multinationals, your compliance runs into jurisdictions. And so you need to be able to have compliance mechanisms, not just internally, but externally, whether it's with a regulator, whether it's with the government, internally would be with their shareholders, with the board. And so those are the key objectives. How do we overcome the challenges? This is a continuation from the previous slide. How do we cure? Because we want solutions. I want us to leave this room having some tangible ways of saying, going back to organizations, looking at our contract management systems, and then saying that we want to identify what are our key success factors. How are we going to cure? The first thing is develop the contract plan. And the activities within that are, and I am looking at this from a perspective where you don't even have an automated system in place. So we are starting. Remember this seminar is called Contract Management 101? Yes. So the first thing is have a contract request or order form. And this is going to guide the other departments that depend on the legal department. So generate one. And it's not rocket science. And I want to say this because a lot of times we copy and paste, maybe from the internet or from our colleagues. Just sit down and understand the unique characteristics of your organization. And once you have that understanding, put it down on paper, write it down, and then ask yourself, how would I want this request to look like? What do I need? Do I need to know the name of the department? I need to understand what are the approval processes within that department. And so for the request to come to me, who should sign that request? Okay, what information do I need to be contained in that request form that will give me enough information for me to be able to assist this department deliver adequately or sufficiently? So sit down. It's an exercise that will need to have some of your time, but it's worth it, believe you me. Next thing is the approval form. Most contracts might need to be approved by the finance department because of the financials. They will need to be approved by the requesting department. And so you need to know who within that department has the approval authority. And again, most organizations or some organizations will have an authorization matrix. So it's important to also understand if it's there, a policy. And that's my third point, the contract signature authorization policy, is to also know who has the authority to sign. Some organizations will say any contract of a value of maybe over $100,000 needs approval by the CEO. If that's the requirement, then you need to be aware of it. So the approval form, and then you go to the signature authorization policy, and this is two-pronged. So it's from the department and it's also from the legal department. Once you have prepared the contract, who must approve it before it goes to the vendor or the contracting partner? The procurement policy is very important for you to understand because again, they have their own evaluation process, they have their own approval process, which you need to be aware of. And if it's not there, help prepare it, because this will really significantly ease your job when you're onboarding a new vendor through a contract. Standardized contract, I find, are a very good way of really supporting the organization and also lessening your work. So for example, if you're in our organization, we deal with the masses, both the wholesale and the retail market. And so I cannot review contract for each and every retail customer. And so the best thing is to standardize that contract. Standardize, for example, your simple contracts like your NDAs. And that really helps, because if you're able to standardize it and even automate it, because you will have created the matrix within which that contract has to be executed, or compliance requirements are around that contract, then it means that the other departments don't have to come to you every time they need a very simple contract like an NDA. Risk evaluation matrix. Our job as lawyers is to manage risk. And please remember that if you're to take away anything, is to how do you manage risk, contractual risk. And so you need a matrix. You have to look at, and this is an exercise that I had to do very early on when I joined the company, and it's a document that you must review as often as possible. Anytime there's a new law that comes into place, you need to be aware of that law, and you need to be aware of how that law impacts your organization. So a risk evaluation matrix is very important. And what I did was look at all the laws of the land, and then identify those that affect the business directly, indirectly, and develop a matrix in terms of, is this a high value, or rather, is this a high risk legislation? What are the penalties? What are the consequences of non-compliance? And then you have to then share that with the business. Generally, that will be the CEO or the board. And then you have to monitor it constantly. And that has to form part of your contract plan, because should anything happen to that legislation, maybe there's a change or there's non-compliance within your organization, the consequences could be dire, even as far as losing maybe your license or your permit to operate. And again, that falls squarely within the legal department. And I really want to highlight this, especially for heads of legal department or general counsels. And then the contract change policy. Now, change sometimes could be inevitable. The scope could change. The demands of the organizations could change. And so you're requested to go back and review a contract, either prepare an addendum or change certain provisions within the contract. So what is the policy in place? How is that change supposed to be effected? Sometimes you're just called on the phone and you're told, oh, we need an additional XYZ added into this contract or demanded from this supplier. There is no process that is followed except that you received a call from the head of another department. How do you act on it? You do not want to expose yourself, because sometimes maybe the requirement is that any change has to go through another approval process. And if you fail to observe some of those processes, the consequences really could cost you your job. So we need to cure that by developing that contract plan. The next thing is to automate. And I cannot repeat this enough. We are living in a world where technology is really accelerating at a very fast rate and changing how we operate. We just are coming out of a COVID-19 pandemic, where most of us had to work from home. And so it was not practical to go to the office and retrieve a contract and then advise the business. And how did we do it? Those of us with automated systems, it really made it easy. But those without, it was difficult. And so the reality of it is that you need to be able to show value and need, create a scope showing the need for why that automation is important. Because one way or another, in the next couple of years, and I predict that to be less than 5 years, everything will be automated. We are already seeing that in a lot of organizations. And I know organizations, even in-house departments, that have adopted systems that review contracts for themselves. We are seeing that. So it's not something that is still in concept mode. And then once you have scoped, shop around. Now, why shopping around, and that's the procurement process, is important, is because there are very many systems out there that might not be, one size does not fit all. So you need to understand first your unique demands as an organization, and identify a system that then would fill those needs unique to you. What I find helps is maybe having a system that you can grow into. There are systems that are purely central depository systems. Their work is just to store contracts for you and to give you, just an easy overview of where your contracts are. But there are others that are enterprise-wide, integrated within the entire organization, close to what we have implemented at my organization. And so you need to understand what the need is, but also importantly is the cost to the business. So is it easier to start with a simple system and then you can deploy newer ones as you move on? But it is possible, and you can actually find very simple CRM systems that can just help you, at least at the very least. What we want is to be able to have an overview of where all our contracts are. And so that's really the first, our really critical role at this point. And then secondly is stakeholder education and sensitization. And this really is so important. And I know it's a soft skill and some of us shy away from doing this, but constantly sensitizing your organization and engaging with them, just training them for them to really appreciate what the role of the department is so important. Don't assume that everybody knows. As I said, most people look at the legal department as the last point of call. When we have an issue, crisis, dispute, then now we remember there's a legal department. But if you are constantly sensitizing them and talking to them about what you do and how you can support them, you start showing your value proposition as a department. And remember, at the end of the day, they need to see the value you bring to the business. And remember what I said, businesses speak in numbers. If you're able to show that by having this system and having a contract management plan, we are going to save the business XYZ in potential losses, and you put a figure to it and you can stand by your figure, don't just pick a figure from the air, then you start speaking the language that the business understands. I have put two items in asterisks below there. One is manage what you can. And what do I mean by this? Let's not go into the organization guns blazing and saying we need an automated system right now. What are the low-hanging fruits that you can quickly ride on that can help you start putting your house in order? Really developing the contract plan and the activities I've talked about are some of the low-hanging fruit strategies that you can start implementing. Just deploying and developing those frameworks that will start helping you towards the end goal and the key objectives that we talked about. Then effective communication. As I said, business understands numbers, so be effective in your communication. Don't just go and bang the desk and say, I need this and I need, no. Effective communication. Show your value, and that's one of the way of communicating effectively. That's all from my presentation, and I really hope that you have some key takeaways. Thank you so much.
Thank you very much, Caroline. Now we have all heard Caroline, and I think our presentation was very straightforward, so I don't have to repeat anything. I would now like to invite Gloria Tengera. She's the chairwoman of the In-House Lawyers Committee. Gloria? Yes, Gloria. We have a lot of questions, as you can see. I think we should go straight ahead to asking questions and answers. So I'll leave that to you.
Okay, so there are a few questions. There are questions from the Q&A side that are being responded to. So maybe I'll start from the ones on the chat. And if I allow me to read through. There was a question on jurisdiction clause. Colin is asking, when contracting parties are from different countries and one party insists on its national laws to apply rather than the international mutual law, this might cause a dilemma to both parties. So how can one address this dilemma, especially when dealing with state-owned entities? Maybe either Soila or Caroline can answer that. Do you want to first take this question before I ask the other one? How would you like to proceed?
I think Caroline Soila. Maybe you can proceed with all questions as they try to process the answers as well, and then maybe they can answer one by one. Just go on ahead.
Okay, sure. Then Jane asked, in the Kenya Public Procurement and Asset Disposal Act, contract management is under the purview of the procurement supply chain management. How do you reconcile this with the discussion on contract management and contract administration? Then Colin asks, how do you handle politics, in brackets, non-legal issues around renewal and extension of contracts? He's explaining that this happens when a new management comes into organization. Then he's also asking for recommendations on an appropriate software for contract management. I think the speakers have talked about a contract management system, but is there like a specific one you would recommend? That's what Colin wants to know. Sharon wants to know how and to what extent is a lawyer's involvement in contract performance in an organization, especially when contracts go wrong and legal is blamed for failure to manage the performance. Fabian asks, legal officers are spotlight for bosses to transfer liabilities on contractual issues when problems arise, but especially in procurement perspective, almost all initial issues relating to creation of the contractual relationship are done by the procurement officers. In relation to contract management and administration, how will lawyers keep themselves safe against a burden of liability when the contract execution fails? I guess he's responding to the problem of fragmented decision-making. And then somebody's asking whether Simba can share with us the risk evaluation metrics for our reference. So maybe let's take those questions first from the chat. Who wants to go first, Soila or Caroline?
I can go first.
Soila?
I can go first. Okay, so.
Please, Caroline, please proceed.
Oh, sorry. I had you call out Soila, so I was retreating. But I missed the first question, Gloria, so I will try and answer the others, and maybe Soila can just add on in case I have left anything. In most public institutions, actually all of them are mandated by law to observe the procurement acts within our various jurisdictions. And so as the legal department coming in, you definitely must observe and respect what the act requires. And so what I always recommend is acquaint yourselves with the procurement laws of your country. Understand the process, because in as much as we have said in our presentation that you need to maybe take charge of the onboarding exercise, you might not have that leeway. And that's the reality. So acquainting yourself with the procurement laws and understanding then within the context of that law, what the procurement process is, will help you in then developing within your department processes and frameworks that are aligned with the act. But you cannot go and say, oh, we must procure this system or we must do this if it's not within the context of the law. So it's very important for us to highlight that. Now, somebody talked about, I think the question about the politics and I think around renewal processes and non-legal demands. I think you said it, it's politics. So politics really, in as much as they go on, and we are very much aware that this is our reality in most institutions. As a lawyer, what are you hired to do? because you're not going to run away from politics. They exist. What I always advise is make sure that any communication, any requirement, any change is in written form, because you have to remember that you need to cushion yourselves from the potential for exposure. And if the undercurrents within the organizations are very political, is that the more reason why you need to have communication to the legal department in written form. And that is a way of you building your evidence should anything go wrong in the future. So they say that you teach people, you train people how to work with you. That's one of the ways. Anybody calling you and saying, I need this done, or by tomorrow, there's a renewal that must be, we want to renew a contract with this vendor, we think he has performed well, please send that communication and that requirement to me in writing. And then what you can do, if you have put your contract management plan in place, is that then you're able to tell them that the requirement for renewal, for example, must be sent to us 5 days in advance or 10 days in advance. And the reason for that is because we need to actually evaluate, and we need the requesting department to give us substantive evidence of how this particular supplier or vendor has delivered for us to be able to make a decision. Maybe issues arose during the contracting period, and you need to then go back and ascertain with the department whether really that, there was full and proper compliance and performance before you initiate the renewal exercise. The other one was on, I think that if we can recommend softwares, what I would like to say, remember I said that every organization is unique, but there are a lot of softwares that are sold out there, and which you can Google and you can find quite a few, but there are also suppliers that you can on board and who would help you devise a simple system. What we use at where Jamii Telecom where I work is called the e-contract system, e-contract, and it's by an organization called Optimus, which is based in India. But that's just one system. The other one is whether I can share a risk evaluation matrix. Again, there are very many that you can find online. If you just Google risk evaluation matrix, you can find them. But really the objective is identifying the law, applicable law that would affect your organization. And I know we are from very many different other jurisdictions. So if I was to share one, maybe just in template form, but because it's unique to your country, you need to be able to develop one. So I would highly encourage that. I don't know if I have missed anything. Contract performance, I didn't quite get the question, and maybe Soila can pick it if she understood it. Thank you.
Thank you, Caroline. Soila, would you like to pick up? Would you like to add anything?
Maybe I could answer one on jurisdiction. I've seen there's a question on jurisdiction, which is a question that has been repeated a lot, even in the Q&A. Yeah. Just to add on what Caroline has said, as an in-house lawyer, we need to understand that our role, one of our roles is to protect the business. Even though we are lawyers and we have that profession, one of them is to protect our business. So when we are making decisions, we need to think about its impact to the business. And as I was looking at the issue of jurisdiction, as I answered in some of the Q&A chats, it first starts in recognizing that your first loyalty is to your company. When we are going to the negotiation table with a certain party, your first loyalty is to your company. And then secondly is where are the assets in this contract? Where are they located? That should form the basis of this deciding what jurisdiction should apply. Are they located in your country? Then you should insist that that contract apply from where the assets are found or where the contract will be implemented. For example, if it is in Kenya, then the law should apply is Kenyan law. But on the other hand, as parties, you can agree that we are going to use the law, like English law, to form the basis as the basis for applicable law. Maybe it is a French company and a Kenyan company, and we say that the English laws are the ones which will apply. So those are the three criteria I would use. First, starting looking at your organization first, number one, because the organization takes the lead. Number two, look at where your assets which are being referred to in the contract are. Number three, look at where the contract is being implemented, which country. And number four, then you can decide as parties which laws you're going to be applicable within the contract. I've seen, just to add, I think Caroline has answered most of it, but on the issue of keeping safe or where liability is transferred, I just want to agree with Caroline. Number one is that everything should be in writing. Do not agree to give legal advice on calls. I have seen that a lot. People want to call you and say, just a quick one, Wakili, can I just get this? That information can be misconstrued. Someone will only take the half part of the information you gave them and forget the second part which you told them, the part which they do not want to do, the part which needs them to do something. They will not take that part of the information. They only take which is easy to do. And when they're asked, so who gave you that? Legal said it was okay. So it is always best that these questions or contracts or whatever is being asked you that you clarify on is addressed, is done to you in writing, so that you can answer adequately also in writing, and you can give the loopholes or something that you may need for them to mitigate, and which sometimes the business do not want to do that. And I agree with Caroline that we have to play the politics. It's among one of the soft skills that we need as in-house lawyers, is to how to play the politics, is how to talk to people, to understand people, to understand different personalities within the organization and know how to remedy. Because even as we are working, we cannot work as an island. You need to go to talk to the business people, understand what exactly do they need, do they want to achieve with this contract. Then from there, once you've understood what they really want, then you can see what can we mitigate, what can we avoid, and then from there come up with a solution tailored from that. You cannot use one mindset for every situation. Every situation has to be assessed individually. And I think that is my answer for those two questions.
Thank you, Soila. I kind of looking at the different questions on the Q&A, I think we might have contract management 1 or 2 at this rate. I don't know if we'll be able to answer all of them, but I would like to give Omar an opportunity to ask his question. You raised your hand. Omar, are you still with us?
Omar, you can proceed to unmute and speak.
If there's anyone else who also wants to ask a question, please raise your hands.
I see Magire.
Migire Kembo Migire, please, you can proceed to unmute and speak and ask a question. We also have Mercy Oyeki. Mercy, can you unmute and proceed to ask your question?
Hello, good afternoon to everyone. Thank you for the opportunity. Unfortunately, I missed quite a bit of the sessions, but from what I've gotten, it's really been insightful. My question to the presenters is around still on the contracting process, is the negotiating. I find that many times when I'm drafting contracts, I get insufficient information from the users, and I think that's where the contract request form becomes key. And that's my take home from this, one of my key take homes from these sessions. But you find that you're given insufficient terms and you start poking and asking questions so that you can actually develop a comprehensive contract. So how do you manage this? How have you managed this in your practice? And how have you improved the turnaround time for contracts? Because they are key to business and you're trying to push this out as quick as possible to be able to support the business functions. So mine is how have you managed to turn this around so that the contracts come in and go out in as fast as possible, but having reviewed or developed a very efficient and comprehensive contract. Thank you.
Thank you, Mercy. Who wants to take that? Caroline or Soila? Or both of you?
I can take it, Gloria. So what I advise in the negotiating exercise is, first and foremost, have a face-to-face meeting. Because a face-to-face meeting, and I know in the COVID pandemic, it might not be possible, but if possible, please do that. You find that when you sit with people face-to-face, you're able to understand each other a little bit more, and you have the opportunity then to ask questions as they present their case to you. But going into that meeting, you want to come out of there with two things. One, you need to understand the scope, and you need to understand their objective. That is the deliverable. What exactly do they want to get out of the contract? So ask very clearly, what is your scope and what is the objective? And by scope, we mean what this party that you want to supply or you're hoping will supply the goods or the services. What does success to you look like? Present the question in that manner. What does a success to you look like? So for example, we want to onboard a marketing or advertising company. What will success to us, to the company, look like? Okay, so that will help you then scope the agreement. And then the objective that they want, they need to be able to understand it themselves. Remember, you're not going to be able to draft a document, a contract, if the requesting party does also not understand what their requirement is. And in a lot of times, this is the reality because the business is moving so fast. Everybody is trying to do something and they just come and dump it on the legal department and hope that somehow you'll miraculously have the answer in the form of a contract. It's not going to happen. And as I said, remember the mantra that I said, you teach people how to work with you. And I know it's easier said than done, but really start at very early on to say, I'm not going to draft the contract unless you yourself understand what you want me to help you with. Because in many cases, and from the presentations that we have taken you through, if they don't understand, you're not going to understand. It's going to be a question of broken telephone, where ultimately the contract is going to suffer. So you will have an ineffective contract that somehow you expect the supplier is going to deliver to your satisfaction. It's not going to happen. So that's very, very important. And then the timeline question is, how do you, input that into the process? I know time is a factor. Businesses are moving very fast. And so if you have a contract management plan in place, this is where it comes to help you. Because once you have segmented your contracts, you know which are high value contracts, we know which are simple contracts. Remember, we said for some, you can even have standard documents where they don't need to come to you, is that then the engagement becomes limited to only those contracts that are very important. And those are the ones that then you have to put in a little bit more time that is normal. And so you plan yourself around that management work plan.
Thank you, Caroline. Soila, you want to add anything to that?
No, I think it was adequately answered.
Okay. So I'm looking at my time and I think we have 5 more minutes before we end. If we could have maybe one more question from one of those who had raised their hands. There's Mijire. Okay, there's Soka. Soka, are you able to unmute? Any of you who have raised your hands, if you're able to unmute, you can
Yes,
ask
hello.
a question. Yes, please go ahead.
Yes, can you hear me?
Yes, we can hear you. Please go ahead.
Yes, my name is Deodato Soka from Tanzania. I have a question. I've been facing some challenges, especially when you are trying to face procurement contracts. So some of my colleagues have been challenging me that most of our procurement contracts are in a standard form that cannot be improved in anymore. And sometimes you might see that you need to improve anyhow. So I would like for the presenters to advise me and my colleagues as well. What can I do if that is circumstances happen? Thank you.
Thank you, Soka. Maybe Soila, you could take that one. He's asking, how can you amend standard contracts? What process can you take? Can you go through?
Okay, thank you, Soka, for that question. I agree. You see, standard templates come to help us to save on time and to ensure that certain key clauses in our contracts are not missed out. But they should not, on the other hand, be rigid, that we cannot improve on them, especially when we get feedback from the business teams. You should look at the clauses on which they are saying have issues. Is it an issue of, it doesn't make sense anymore? It is not up to date. Is it very punitive on the customer? So look, have a sit down with them, have a sit down with the business teams, find out what exactly is the problem with the template as it is. What clauses do they have an issue with? Once you agree which clauses they have an issue with, let us see how we can amend them to suit the business, yet still complying with the law and any regulatory requirements. So that way it is a win-win for both. But our templates should not be, actually, after a year or two, you should look through your templates and see how you can update them, how you can amend them, and sit down with your business teams just to have a one-on-one and understand what their problems are when they are submitting this template to the customers. That way, once you get that feedback, implement that feedback into your template and see what you can change in your template and make a template which is a win-win for both. Because we must remember, as in-house lawyers, as Caroline has kept on repeating, we must remember our work is also to add value to the business. We are not there to just put in barriers for the business, is to add value to the business. So is your contract adding value to the business? Is it making business easier? So those are the things you need to look at. Thank you.
Thank you, Soila. We have, I think, 1 minute or two for one more question. Slim
Abdallah.
Yes, please go ahead.
Thank you. Hi, everyone. Happy to be here. My question is a bit small. I'm very much interested with some software mentioned here, which will be used for tracking the contract, especially when you're serving like big corporate entities with 100 and 1,000 contracts. As you know, and you are the eyes. So, and some of the time it appears that you're working from your office, you're not in-house counsel, but still you're doing some assignments as if you are their direct assistants. How do I get this software and where I can buy them from? Thank you.
So I guess this question has been answered before. Caroline, I think maybe shed some more light. Sorry, you're muted, Caroline.
Sorry. I don't know if you can. Was he asking for referral to where he can get a system, a software? I don't know if I understood the question.
That's what I understood. Slim, is that what you were asking for, essentially?
Yes, of course.
Yes, that's what he was asking.
Okay, as I said, maybe I can just give you the process of procuring one. And what we did as an organization was send an RFP. And so you can generate one because, as I said, you need to know what your requirements as an organization are. And there are very many companies that are selling software. You can ask around, your procurement department can guide you to one, but if you can't find one, because I would really not be in a position to give you the names of the suppliers, but they are there. You just need to find them. You need to look around, and if you Google, you can also find a few that have listed themselves online. It's just like any other software. So for this particular one, it would be a contract management one, but it's just like buying or purchasing any other software. And so in this case, you would then indicate that it's for managing your contracts. And I remember what I said during my presentation, it could be a standalone system, which is purely for the legal department, or it could be an enterprise-wide one, like most ERPs that we are using already in organizations. So you just need to scope, and then you can shop around. And as I said, there are very many of them around. Thank you.
Thank you, Caroline. We do have a Caroline there with Gidinji. Do you want to ask a question?
Hello, you can hear me?
Yes, we can hear you. Please go ahead.
Yes, I had a question related to implementation of the contract. I recall someone put it in the chat box, but I don't think it was properly, I really got the answer. So you've done the contract, you have your own tracking system. You can advise the company when is a contract due for renewal, what are the risk elements. You've done all that, but the issue is on implementation itself. And I find that when the implementation doesn't go well, legal is always the one that is blamed. But sorry. Oh, okay, sorry. So you find that legal is the one that is blamed for not, well, the argument normally is one, that you did not manage the implementation and follow up with the respective departments and all that. And two is to mitigate, because sometimes it's your company that is in breach. You've already highlighted this breach that is there, but well, the people are not listening to what you're saying. The action is not really there. So I was wondering if the panelists have any ideas on how to handle such things when it comes to managing the implementation itself. Thank you.
Thank you, Caroline. Soila, do you have anything to say to that? Or Caroline?
I can start, then Caroline can add on to something. Okay. When it is unusual for a company or an organization not to implement their obligations. So as I have said before, it is important for legal and the business teams to act as one, because at the end of the day, we are still one organization. So you need to sit down with the business team and understand what is the problem. Why? Because you've already notified them they're in breach and nothing is happening. You need to understand what exactly is causing them not to implement their obligations under the contract. Once you understand that, we can now see what in the contract, what we can do to mitigate this situation, because it could be a force majeure kind of situation. What can we do about that? We can invoke that clause. It could be a situation that the other party has not done their obligation, then we are prevented from carrying out our obligations. So once we understand what is happening, then from that situation, then we can answer or remedy that situation. And I want to advise you, Caroline Githinji, that do not be rigid, and do not take one, like the answers you're given here as apply to or copy paste to every situation. I think as an in-house lawyer, what I have learned mostly is that every situation, assess it individually and see how you can assess the risk in that situation and find a solution for that situation. But if you take a copy and paste kind of way of doing things, then you'll find yourself that you're not able to cope with the business team, because business is dynamic, it's always changing. So if you approach it in that way of trying to understand and see how we can mitigate, you might be able to find a solution. Thank you.
Thank you, Soila. Caroline?
Yeah, I would like to add this. And that's a very interesting question from my namesake. One of the reasons why implementation tends to be difficult is because, and this is from my experience, organizations tend to view contracts from an obligation perspective, as opposed to from an enabling perspective. And so we are coming into the contract because maybe the other business partner said, let's conclude a contract, but you're not looking at the contract with the lens of this document. Remember I said it's a living document, is what is going to set out clearly what our obligations, our respective obligations are, and it's supposed to be an enabling document, a document that enables the parties to deliver on their respective obligations. So if you change that mindset, then you start to appreciate what then needs to go into the contract. Because it's an enabler, you have to be then very specific and as detailed as you can. Now, it's not to say that the contract is foolproof. It's very much possible that along the way things change, because as Soila has said, organizations are dynamic. Every day something changes. But if you understand the contract as a living document, you will go into the negotiation to understand the parties' needs and requirements, and then find a way of capturing those very well early on. The implementation tends to be difficult when the contract does not capture those intentions adequately. And so it becomes very difficult to implement that which is not clear, because what are you implementing? This person has a different expectation, the other person has a different expectation. So, and that is why I really say, please try and walk with the other departments, walk in their shoes. Actually, within our organizations, there's something that I started just before COVID, which we call Wakili Mashinani, which is interpreted to mean your lawyer, your trusted business partner, or your lawyer along your street. And what that was, the reasoning behind that was that as legal department, I encourage my team to get out of their desks, their offices, and sit with the other departments at least once a week. Sit with them from morning to evening, understand their challenges, just be part of their process. And with that, you start to change your mindset in understanding the unique challenges that the various departments are experiencing in their day-to-day. And over time, what we have found is that that helps the quality of contracts, because now you're coming in to support them really truly at the very early on, before even the contracting process has started. By the time you're designing and drafting that contract, you have a better grasp and a better understanding of their unique challenges. And that really has helped with the implementation, because now you're wearing their shoes, you understand, you feel their discomfort, and you're able to capture their needs and their concerns very well.
And with that, I think this webinar is coming to an end. Thank you so much, Caroline and Soila, for your words of wisdom. I'm sure most of us take with us a lot to chew on. But I think the most important thing for me is basically what value are you adding when you work on a contract, and what structures do you have in place to ensure that you're tracking your contracts? This for me is a takeaway from this 2-hour webinar. I would like to thank the ELS team for always making this possible. Our moderator, Amina, thank you so much for taking us through this. And for those questions that have not been responded to, the Secretariat will extract them for us, and we'll send the responses on email. The slides and recording will also be shared on email, so don't worry about that. And have a good afternoon for the rest of you. Thank you.